As I call the first panel to the table to continue this conversation, think about this conversation that we just had, because it sets the frame on this picture. When energy projects finally roll out on Mexican land and they extend from Tamaulipas to Michoacan to the ports of Mexico to indigenous lands to different places, as this investment unfolds, these projects will come in contact with Mexicans everywhere. Mexicans who are hungering for justice, who own land, who feel that their rights might be trampled, who may feel that they have no venues to appeal to if they are wronged. Water, land, justice, basic arbitration in disputes between communities and farmers and energy companies. So the rule of law, the energy reform is about to bring a huge problem with the rule of law in Mexico as energy reform implementation unfolds. And so these essays that you're about to listen to were commissioned with this in mind. Let us anticipate the land dispute problems, the water dispute problems, the use of the natural resources, the environment, the environmental damage that can come from energy reforms, and how the people that own the land or have the right to the land are going to get those wrongs redressed. So clearly, energy reform opens up a whole new horizon. And this is why we decided to connect these two things, energy reform and the rule of law. So the conversation on the rule of law on a day-to-day basis is not irrelevant to energy reform. Is that this book, these essays that you're about to listen to, try to address that specific intersection of energy reform implementation and the problems with the rule of law in Mexico. And I think Luis's introduction was really wonderful, and the questions were really also very good in setting up the debate that we will have for the rest of our day today until about 3 o'clock. I'm going to invite the next panel to the table, and that is Dr. Oscar Lugo, who will be our moderator. Oscar, thank you very much, from the Universidad Autónoma de Nuevo León. Thank you. And then Gabriel Cavazos Villanueva, and Francisco Monaldi, our fellow in energy here at the Baker Institute, and Isidro Morales, a foremost expert on energy. The panel is Global Energy Markets and Investment Protection. And I'm going to explain the dynamics to make it a more dynamic conversation. What we're going to do is we're going to give about 5 to 7 minutes to each of the presenters to bring their major concerns to the table. And Pam over here in front of our research analyst will have some cards. So when your time is running out, Pam will raise that card, because we want to give the most time to the conversation and to your questions. So about 5 to 7 minutes, Oscar, perhaps for each of them, and then we'll open it. Perhaps Oscar may begin the round of conversation, the question and answer session, and then we'll open it to you to have a broader conversation on this. So Oscar, the panel is yours. Thank you.
Okay. Well, good morning. Thank you very much for your attendance and for the invitation for the Rice University and the University of Houston to make this possible, these essays that will be presented today. And as part of the University Autónoma de Nuevo León in Mexico, we are very proud also to participate in this event. Well, we'll begin with the speakers today. We have Gabriel Cavazos, which is Associate Director for Social Science and Humanity for the School for Business, Social Science and Humanity del Instituto Tecnológico y de Estudios Superiores de Monterrey. Francisco Monaldi, which is Fellow in Latin American Energy Policy from the Baker Institute Mexico Center, and Isidro Morales, which is Non-Resident Scholar from Mexico Center, Baker Institute, and Senior Professor and Researcher from Instituto Tecnológico y de Estudios Superiores de Monterrey. And this panel will focus on global energy market and investment protection. So we'll begin with Gabriel Cavazos.
Okay. Well, thank you very much, Oscar. Thank you for the kind invitation to participate both as an author and in this relevant collective work and as a panelist in this event. I'm very proud to participate in this panel with this expert, with my colleagues, Francisco and Isidro. My very modest contribution to this work is entitled Arbitration and Investment Protection in the Context of Mexico's Energy Reform. I like to think on international arbitration as a form of global governance. Luis Rubio just mentioned NAFTA as a form of governance in the context, or in the North American context, both for trade and investment. I have been participating for some years as a panelist or arbitrator in one of the NAFTA mechanisms for the settlement of disputes, in this case anti-dumping and countervailing duty disputes, which is a very specific and technical issue. And I have witnessed this binational dynamics that is working. And arbitration in this respect, and specifically for investors in the energy field, I think it's going to be very, very relevant. I think it's going to be of a crucial importance. Because foreign investment in the energy sector is of a crucial importance, and we all know about that. And sometimes the lack of a global policy framework for energy investments makes transnational companies sometimes hesitant to invest abroad in complex, long-term energy projects. And what do we have? What is the context of this legal framework in terms of this global governance that I was referring to before? We have what some authors call an international energy investment law. In the shape of free trade agreements with an investment chapter, like NAFTA, for instance, bilateral investment treaties, and the Energy Charter Treaty, which is mostly confined to the Eurasian region, not including Norway, not including the Russian Federation. So the global framework is there, but it's not really strong. And on the other hand, arbitral tribunals, they work as ad hoc bodies of adjudication, and they are conformed just for a single arbitration, and when the arbitration it's over, the arbitral tribunal disappears. It's not like a permanent body of adjudication. So that's what we have. Probably, however, the most dynamic area in public international law is this one, international investment arbitration. We have seen many cases of investment arbitration involving countries which have had an energy reform. That is the case of Argentina. Most of the disputes of Argentina in international investment arbitration come from energy cases. So a key question in our paper is whether investment arbitration available for foreign direct investors in Mexico's energy sector, in spite of the reservations that Mexico has kept in relevant treaties, such as NAFTA. And my answer is yes, it is. The article itself is divided in 3 parts, and it analyzes the role of arbitration as a dispute settlement mechanism in the context of Mexico's energy reform. Of a particular importance is the fact that laws of Pemex, the Mexican oil company, and CFE, the Federal Commission of Electricity, do not include the concept of an administrative contract, and therefore the concept of administrative rescission. And without an administrative rescission, arbitration is possible under those laws. However, the hydrocarbons law that applies for issues of exploration and extraction kept the concept of administrative rescission. And despite the inclusion of an arbitral clause in relevant contracts, administrative decisions are not subject to arbitration, and that involves a decision of the Mexican Supreme Court in that sense. By the way, I think, and I was thinking about Luis Rubio's presentation, and I think the Supreme Court of Mexico has played a crucial role in the rule of law recently as a form of institutional strength. So the controversy that surrounds administrative rescission is analyzed through a very famous case, the case of an American company incorporated in Mexico, Comisa, which had an administrative rescission in a Pemex contract. And this case commenced way before the enactment of the energy reform in the Constitution. So the case illustrates how problematic an energy dispute can be, even when arbitration is an alternative. Finally, in this paper, and using the case of KBR versus Mexico, and KBR is the parent company of Comisa, the Mexican company, and it's an American company. I take this case as an example and discuss the possibility of an investment arbitration even when Mexico has kept reservations in the energy sector. So as I said, in NAFTA and other bilateral investment treaties, Mexico has kept a reservation saying that investment in the energy sector is still in the hands of the government or of the state. That has not changed in the international treaties. So that's important to mention that, because everything has changed in the Constitution, in the implementing laws, but not in the international treaties. The reservation is still there. So the fact that Mexico has not, in this case of KBR versus Mexico, in which this American company is complaining about the treatment that the Mexican government has given to their investment in Mexico, the fact that Mexico in this case has not argued the reservation means that, at least in my opinion, that once an investment is allowed, the investor is subject to the protection of the free trade agreements or the bilateral investment treaties, and the reservation applies as a defense for Mexico to prohibit a specific investment, but it cannot apply after an investment has been made, especially when there is a violation to some of the standards contained in the relevant bilateral investment treaties and in free trade agreements. There is a standard called the Fair and Equitable Treatment Standard that involves that an investor cannot receive a treatment that implies a denial of justice, a lack of transparency, and treatment from the state that it's somehow arbitrary. So if a standard like this one, the Fair and Equitable Treatment Standard, is argued by the investor, even though we have a contract that allows for an arbitration for the contract itself, we could have a different kind of arbitration that would be an investment arbitration that would not involve only the issues covered by the contract, but the general treatment that the investor has received during the time of his or her investment. So I would like to conclude saying that, as I said at the outset, that I think of arbitration as a way of global governance, a very weak one, but it's a way of global governance, just as transnational litigation is a way of governance, just like strategic litigation in a domestic context is also a way of governance. So arbitration, both contractual and investment arbitration, is going to be crucial in the context of the energy reform. And I think further in-depth analysis is necessary in this area. So my contribution refers to recent examples of arbitration and the possible scenarios for the future in the context of arbitration in the energy sector. So thank you. I think I have done on time.
Yeah.
Thank you very much.
Thank you very much, Gabriel. And now, Francisco Monaldi, if you want to speak about your essay, please.
Yeah, thank you. So I will talk to you a little bit about what I think are the conditions for the protection of the property rights of foreign investors in the Mexican oil industry, using as background what has happened in Latin America, in other countries in Latin America in the past. So most of you know Latin America has had cycles of opening the oil sector that have been in many countries followed by expropriation in a broad sense, including nationalization, but also changes in taxation, in regulations, and in contractual agreements that have not allowed investors to recover the investment as was planned in the original deal. And that has happened in some countries many times, in Argentina 4 times, in Bolivia and Venezuela 3 times, in Mexico 1 time, in Ecuador many times. So there is a reasonable worry from the perspective of an investor that in this region, property rights in the oil sector, of course, as well as in other sectors, but in particular in the oil sector, are not necessarily well protected. Why? And by the way, the cycles, the recent cycle that we saw, Argentina, Bolivia, Ecuador, and Venezuela doing some form or another form of expropriation during the last decade, usually are followed again by cycles of liberalization, because once the conditions are ripe for, when the governments actually are very need of investment from foreign companies for a variety of reasons, they open the sector again. Of course, the difficulties of attracting investments once you have been in the past an unreliable partner are significant. What are the factors that explain these cycles? The first factor is the issue of oil prices. It's well known throughout the world that when the price of oil goes up, there is a tendency of renegotiating contracts and sometimes to nationalize the oil sector. The reason partly has to do with the fact that some of the fiscal regimes in many of these countries are regressive, meaning that when the price of oil goes up, they do not capture most of the additional rents, and so governments are unhappy with the deal and change the rules. So part of the explanation has to do with the fiscal terms, and that's, I think, an area in which things could be improved. And we can talk later about some details about that. The other issue is the investment cycles. Once you have had a very significant set of investments that have increased reserves and production, and once the initial risk, for example, of exploration had been, if you have been successful and you have found a significant amount of proven reserves, the state has significant incentives to change the rules, because first of all, the large sunk investments are already in place, and as a result, if you change the rules, but still the foreign investor can cover the operating costs, they will have incentives to stay producing, and that's known by the government, and therefore the investor is trapped, and they have this difficult situation. And also, if you won the lottery of the geological lottery and found significant reserves, then usually the government is unhappy about the deal that they offer you. Ex post, the risk did not materialize, but the success materialized, and so they don't want to compensate you for the risk that you had ex ante. So the combination of investment cycles and price cycles are a significant component of these cycles of opening and expropriation. So the Mexican oil reform, in part, fits this pattern because Mexico was the only country that did not liberalize the oil sector in the 90s, basically because it didn't need to, because previous investment had opened the opportunity of developing the reserves of the shallow waters of the Gulf of Mexico, and Mexico could, without a significant investment, increase production in fields like Cantarell, and so there was no pressure for the Mexican government to open their very productive cash cow, which was Pemex at the time. Of course, that meant that they didn't, the over-extraction of rents from Pemex meant that they didn't invest enough in exploration, and at some point, about a decade ago, production started to collapse in Cantarell, and Mexico faced a difficult choice. The price of oil at the time was going up, so that made it less compelling, and that's, I think, one of the reasons why the reforms attempted by President Calderon ended up being so timid. Of course, partly because of significantly because of the opposition of the PRI and the PRD, but I think it was the pressure was not as big as they faced afterwards, when production kept declining at a significant rate. So Mexico opens up its oil sector because it needs to, because basically the increase in investment requires is massive. The risk in the deep offshore areas, in shale and in unconventionals, are very significant, and the technology required, and the expertise is not there. So it fits the general pattern. Mexico has some attributes that will that should scare foreign investors, which are two. One is the fiscal dependence of the Mexican government on oil. That's usually a bad element for the protection of property rights, because if a government is so dependent on the fiscal revenues from a sector, they have the tendency that in dramatic situations they have very strong incentives to change the fiscal rules. And they are a significant net exporter. However, I do think that there are a variety of conditions, and Luis Rubio mentioned some of them, and Gabriel, that potentially make Mexico a different case from other in the region. First of all, the constitutional reform, compared to other countries that basically did their opening through, sort of small pieces of the law that allowed for opening the oil sector. Mexico went through reform of the Constitution, and which requires 2/3, and then the state's legislature approval. So it is a relatively difficult thing to reverse, and it was part of a big political debate that went through a process in Congress. Second, Mexico has developed all these sort of cumbersome system of checks and balances in the design of the reform, in which you have Hacienda, the Finance Ministry having a role, the Secretary of Energy having a different role, then the Autonomous Comisión Nacional de Hidrocarburos, the CNH, having another role, and all those things make it, in a way, too cumbersome. Some have criticized that, maybe rightfully, but it does provide a significant set of checks and balances that make unlikely that something like what happened in Ecuador, for example, in which the president canceled some contracts on in Venezuela, will happen in Mexico. Then, of course, the issues related to Mexico has a rule of law perception above the average in the region, and I think most importantly, Mexico is an economy that it's very much diversified. It's well integrated into the world economy, has many investment treaties, and NAFTA and now TPP will potentially offer eventually some ways to arbitrate. Still, it's important to know that there are two ways in which a reversal of the Mexican oil reform might happen. One is the dramatic case like Venezuela or Ecuador, but then you have the less dramatic case like in Brazil or previously Colombia, which is, in Brazil and Colombia, oil contracts were not forcefully renegotiated, so the existing contracts were left as they were. What they changed were the future contracts after they discover reserves and so the resource nationalism in those countries applied for the future. So it's sort of a less threatening, of course, for a foreign investor, because they don't change your contract, but it does affect the development of the oil sector in the future, as happened in Brazil, for example. So something like that could happen in Mexico. As you know, the López Obrador and a significant part of the left side of the spectrum in Mexico has been very critical of the oil opening and has basically said that they will use it as a political flag in the elections and will try to reverse it. So that's a significant concern. Just let me mention to close up some other features that I think make the Mexican reform relatively well for the protection of property rights. One is the fact that the fiscal system is very progressive. They have a royalty that varies with the price of oil. They have contracts have a regime by which the profit share of the government goes up with the internal rate of return. So that kind of thing makes it less likely that contracts will be renegotiated as they did in Venezuela and Ecuador. Nevertheless, it's important to notice that it will be the case that some years from now, some politicians or other actors in society could claim that the taxation rate of the private projects is lower than the rate of taxation of Pemex, simply because Pemex has already, the most productive fields that are in which the risk already happened, and these new projects have more risk and they are in a different situation. So that could open a significant criticism for the oil opening. Finally, I just wanted to mention that the two extremes are usually bad in terms of reversal of reform. One is a tremendous success. If Mexico discovers huge oil fields in the deep offshore, it could happen like in Brazil, that resource nationalism resurfaces and the country sort of wants to change the oil opening. The other one, of course, is the failure of the oil opening. There have been big expectations that it will be a significant attraction of investment. And if it doesn't happen, and the low price environment, of course, generates some difficulties that might also lead to reversion. So basically, that's what I wanted to tell you. Thank you.
Thank you very much, Francisco. And now, Isidro. Isidro Morales, if you can talk about your essay, please.
Yes, thank you, Oscar. Well, I want to warn you that I'm not a lawyer, so I didn't write a paper on the rule of law in Mexico. I was invited to write a paper on the integration trends of energy markets in North America. So that's what I did, and I think it could be very valuable for readers in order to understand how Mexico's energy reform, or the so-called Mexico's rule of law, adapts to this new continental environment. That's my point. So I'm going to present some slides because I think it's less boring. Slides could be more attractive than the speaker. So I want to be supported by them, and I just want to make oops, must be here, yeah, three points. The first point is what we all know. Energy integration in North America is a de facto reality. Even though there has been some political and policy strategies in order to govern that integration, the fact is that market forces and companies' decisions have accelerated that integration. And what we're seeing here is the role of both Mexico and Canada. Canada has become the strategic partner for the U.S. We all know that North America features a big oil importer, which still is the U.S., but this could change, and two major oil providers, Canada and Mexico. Canada provides currently 32% of U.S. net oil imports. And Mexico plays also a strategic role, but less and less because of the decline of its own production. So the position of Canada is vital to the North American energy system because it's highly integrated by pipelines, both oil and gas, and Canada is the major provider in the Midwest and the Rocky Mountains region, and also in the West Coast. The only really competition confronting Canada with other oil importers is the Gulf of Mexico coast. And this is important to highlight, and I highlighted in my paper, because most of Mexico's exports to the U.S. Enter the U.S. through the Gulf of Mexico. So Mexico is already witnessing the competition from Canadian oils, because Canadian oils they all have different brands, but they have heavy oil. And Mexico, as you know, is exporting mainly heavy oil. So this is important to highlight because this is rapidly changing, and since North American U.S. revolution on both tight gas and shale gas, Mexico could be quietly ejected from that market. That's one of the major consequences that I highlight in my presentation. Well, you may find this also on gas is more or less the same, but here Canada is the dominant player because 90% of U.S. imports come from Canada. The rest comes from Qatar or from LNG. Mexico is a net importer from the U.S., as we know. Now, my second point is what you all know here in Texas, is that U.S. tight oil and shale gas revolution, which is changing radically the conformation of these integration trends, and is making of the U.S. a major gas player, perhaps a global gas player, and it could become also the U.S. It could reduce net oil imports, forcing both Canadians and Mexicans to diversify their markets outside North America. So my second point is about that revolution, showing how Canadian imports are declining rapidly and how Canadians are being forced to sell their surpluses, in this case of oil, to Europe, but it will become the same with gas. Now there are strategies in order to export LNG, also in the US, and you can see here in this graph as well the incredible increase on gas production. In the last 7 years, meaning by this the two Obama administrations, U.S. oil production has been almost doubled, and gas production has increased almost 20%, which is very impressive, provoking these major changes. So, since I don't have too much time, my third point is how the two other countries, Canada and Mexico, have to adapt to the new situation. This is more explorative, and I explore the case of Canada, how they are forced to diversify both gas and oil markets, how Canada could eventually put out Mexico from the Gulf of Mexico coast, or reduce its share in the North American market. But one point that I highlight, that in the new scenario, so we have the American Revolution, but then we have the energy markets revolution, the fall down of oil prices. This is a new situation. I mean, the fact that oil prices have plummeted. And what I highlight, I just explore at the very end of my article, how Canadians and Americans, how Canadian energy industries and how American energy industries are resilient to those changes. What is going on? That's why I'm showing here how tight oil production has not collapsed. It has increased. Even last year, it has increased, in spite of the new environment, which is not very attractive to new investors. But it's the same with Canada. Canada has also increased production, and it's going to increase its production for the next year, which is not the case for the US. But anyway, what I'm saying is that the two industries in the two countries have proved to be resilient. And according to the last forecast, to the recent forecast of the Department of Energy, low prices will prevail this year, but they are going to go up, or they're going to stabilize. Of course, not on the hundreds, but on the 40 or 50 perhaps, from 2017. So, for me, it's a proof of resilience. The exception is, of course, Mexico. Well, perhaps Mexico is in a crisis. There were some questions before about security and so on, yes. But what is really in crisis is Pemex. Pemex has proved that it's not resilient to the new environment. And the new environment in Mexico is twofold. The energy reform, which Francisco has talked about, the rationale, I'm not going to talk this again, and the fall down of prices. And let me tell you that Mexico's energy reform was drafted, was discussed, was negotiated under a different scenario. It was when oil prices were very high. For Mexico was in the 80s, the Mexican MEX, and with too much optimism. Just review what President Calderón and President Peña Nieto said about the future of Mexico's energy reforms, and they were betting that Mexico had to increase its production. Remember that historically Mexico produced 3.5 million barrels a day. Now we are producing below 2.2. And since the Calderon years, the goal was to reach the historical record. And the record was 3. We have to reach the 3 million barrels a day. With Mexico's energy reform, with the new administration, we have to adapt and said, well, we have to reach that 3 million barrels a day, but with a new environment, inviting foreign investors. And to Pemex, they asked them, please don't reduce productions. You have to stabilize production in 2.5. Failure. Pemex has invested more than $20 billion yearly from 2009 to the present, and going down. So it's a failure. We have to accept it. It's a failure. So, as you know, 2 days ago, there was a major change. The Pemex CEO is not Mr. Emilio Lozoya. We have a new CEO. And for me, of course, I don't write it in the paper because the writing is already finished, is a time of inflection. So I think that crisis, Chinese are very good for that. Chinese said crisis is a time of opportunity. Pemex is in a deep crisis, but at the same time, it has its really historical opportunity. For what? For restructuring the company. And I think, and I'm going to stop it because now my time is off, the new CEO has the opportunity in this, the 3 years off that we have, to change the goal. Pemex is not going to increase its production. It doesn't make sense. Prices are very low. You have to reduce production, of course. But you have to concentrate in how to transform the firm in a very competitive firm. And I think there are possibilities. I want to stop there. You know that Pemex is already organized in 4 subsidiary entities. We have upstream, gas, petrochemicals, and downstream refinery. I think that the Pemex strategic value chains must be on upstream and gas. The rest, you can privatize, or you can invite other investors, or you can transform it. I think that would be a scenario in order to save Pemex and in order to make resilient that company to the new environments. Thank you very much.
Thank you very much. So now in the panel, I would like to ask you 2 questions to each one of you, and then you have 5 minutes, and then we can open the discussion to the rest of the public. To Gabriel, I would like to ask, more than 15 years ago, the Supreme Court announced the hierarchy of the laws, and now we have the Constitution, then the treaties, and then the federal laws. And most of the energy reform are part of the federal law. So that this kind of the resolution from the Supreme Court gives more guarantees to the investors regarding NAFTA and the bilateral treaties we have on investment. And the second question is if you could talk a little bit more of these bilateral treaties on how the experience of Mexico regarding them, because I think we have more than 30 bilateral treaties right now, so that gives a lot of opportunities of investors from a lot of countries that they could have this guarantee. Thank you.
Yeah, thank you, Oscar, for the questions. Well, concerning the hierarchy of the laws in Mexico, in spite of the fact, as you mentioned, that the Supreme Court has had some definitions several years ago in which the international treaties are mostly at the same level of federal legislation. I think it's not really well defined, with the exception of the human rights, because in human rights it's clear under the latest reform to the first chapter of the Constitution that human rights international treaties can be even above the constitutional framework when there are some rights not covered by the Constitution itself. So that is a radical change that, of course, does not apply for other types of treaties, including the investment treaties. And that's not irrelevant, because there are 2 major areas under international law in which a private individual or a private party is a subject of public international law. One is human rights, and the other one is international investment, because remember that in international investment, an investor under his or her own rights can sue, in quotation marks, a whole country because he or she considers that the country or the host country has not given to the investment the treatment that it's contained in an international treaty. So I do not feel that, or it doesn't seem to me that the hierarchy of the treaties is relevant. I think the way they function is probably more relevant. And with respect to your second question, I think that the experience for Mexico has been, well, it depends on which side you are, has been very, very interesting. Most of the cases, or most of the investment cases or investment arbitration cases that we have had have been under the NAFTA Chapter 11. Most of the resolutions have been in favor of the government. Sometimes there are some criticisms against the system, saying that it favors the big multinationals, but at least under the numbers, the cold numbers, most of the cases have been in favor, or at least the Mexican state has prevailed. Some cases have been very, very significant, many of them concerning environmental matters, such as metal clad and some others. And some other cases under the bilateral investment treaties have included countries of Europe, such as Spain. And I think the experience for Mexico has been not as bad as it has been for Argentina, for instance. I forgot the number, but for Argentina there are like more than 30 resolutions of investment tribunals, most of them against Argentina. And as far as I know, Argentina has not paid damages yet in any of the cases. So Mexico has paid all the damages when the tribunal has awarded damages against Mexico. Mexico has timely paid the relevant damages. So institutionally, I think the experience has been good in that respect. I mean, the system has functioned, and it is still functioning in that regard. So I think bilateral investment treaties are still important. I would like to highlight again that Mexico has not removed from the treaties the reservations that it has concerning investment in the energy sector, basically in hydrocarbons and electricity. I do not have an explanation for that. I don't know why. There's no Mexico has not removed that reservation. This is probably a matter of interpretation under the Vienna Convention on the Law of Treaties, and some people say that, well, there is an implied removal of the reservation because of the constitutional amendment. That can be an interpretation. But my conclusion, at least in the essay, is that even though we have still this reservation in the treaties, it's not important, especially when an investor has received a treatment that it's considered beyond the international law standard of treatment, and of course we now have a case, this case that I analyze in the paper, KBR, that involves the energy sector. But this is still very early to foresee what is going to happen in arbitrations under the BITs and under NAFTA. But I think, as I said, that the experience so far has been, from an institutional perspective, I think it has been adequate.
Okay, thank you. Francisco, about the cycles of liberalization and the consensus you speak on your essay on how the energy reform was approved by the different political parties. If we assume that the political parties represent really the sensibility or the point of view of all the citizens, it can be said that the energy reform was approved by 2/3 of the population, and 1/3 of it, which is more identified with the left political parties, was not agree with that. But we are having right now the results of the different bites and the rounds of round one, and there has been no people on the streets saying again that we are selling the oil or the gas, or I mean nothing has happened on that part. Do you think that that's a strategy of the political parties, or really there's not right now not a really an issue on that? No, on talking about that. And the other part on your analysis also of the fiscal system, what do you think of that fiscal system? There was some concerns about that it was too complex and that influenced the results of the bite one, but then on the other bites there were very good results with having a lot of companies with the adjudication of the contracts. So, and we have in one side the SAT, which is like the Servicio de Administración Tributaria and the Secretaría de Hacienda, and each of one has different functions on the hydrocarbon sector. Could you explain a little bit more about it?
Sure. Thank you. So yeah, I think it's interesting that there has been no significant political backlash against the first three auctions on the round first. It has to be said that usually, these things happen afterwards. Once the investment have already happened, the pressure to renegotiate happens. So politically, it might be that even though today we don't see any criticism, eventually it could materialize. I think they have done very well in terms of the transparency of the auctions. It has been I think a model in the way it has been executed in that sense, which opens sort of less of these auctions for criticism of corruption or other types of. By the way, even though, as you pointed out, the first auction, only 2 blocks were assigned, in general, including that one, the profit share for the government offered has been very high. In fact, if you look at different analysis of the rate of return after taxes that investors will have, in some of them are very low, or even in the third, in the 1.3, even negative. So it's pretty, in a way, it was tremendously successful for the government being offered such high shares, which by the way, it might sound as very good, but it could be a problem in the future because, of course, you want investors to, have a return on the risk and investment that they are taking. So it's not always, the headline of the first day on how much you got. The reality is that you need the investment to materialize and the flow to go back to the government. So I think it's, the proof will be if a left-wing president wins an election in Mexico, and he has the objective of either reversing the reform or being toughen the fiscal terms, for example. It's important to notice that even if you have all the protections of an investment treaty, even if everything is working out, the details are very important in the following sense, and the general political equilibrium, because the government has so many tools, to punish an investor and to force him to renegotiate. I have seen many times in countries all over the world, the government sends you like tax inspectors every day, for example, until you renegotiate, right? So they are, they threaten to cancel your contract, and you may say, well, I have a protection, I can go to invest. Yeah, but if you cancel your contract and you enter into litigation and all these things, it's costly, etc. So sometimes companies are forced to accept a renegotiation of the deal through a variety of pressures, and that's what investors have seen this again and again all over the world, and that's what they are worried about sometimes, because the nature of the sector is that you have very significant stock investment. The most extreme example is deep offshore. You put $2-3 billion on a project, and then production starts, and the operational cost is relatively small, so they can dramatically change the conditions, and you will still have incentives to operate. So it's a tough environment. In terms of the fiscal system, as you know, in each round it has varied a little bit. I think they have learned a lot from the failures of the first one in terms of first of all stating openly what will be the minimums that the government will accept. For example, between the 1.1 and 1.2 that happened, changing the sort of the limits on how the bidding happened in terms of the companies could be in many blocks and could sort of they reduced those restrictions. It is true that some of the, for example, the profit sharing agreements or the production sharing agreement, are relatively complex. But if you don't have complexity, then you don't have this progressivity that I mentioned in terms of capturing the rents when the internal rate of return go up. And so if you are a country that doesn't have the human resources and the skills for example, in the CNH and other regulatory entities to manage those types of contracts, as I have seen many countries that they do not understand their own fiscal system. That is a problem. But I think Mexico can develop the resources, the bureaucracy to manage these contracts well, and I think in the end it will not be too much of an issue. And I think the system, as I said, in general, it's progressive, and I think it captures sort of the best state of the art in terms of fiscal systems in the world in many ways.
Okay, thank you, Francisco. Isidro, you talk on your essay a lot of the transnational borders and this how these hydrocarbons could influence this our relation with the United States, Mexico, and Canada. And we've seen right now that the price of the gas is cheap, that there has been an announcement in the news that some American companies are investing in pipelines in the northern part of Mexico, and Mexico itself as a state is investing also in different pipelines in the north. Are we already right now in the transborder relation between Texas, more specifically, and the northern part of Mexico? Are we having like a new integration right now, and what do you think will happen later? And I was going to ask you this new role of Pemex, which you explained at the end, and I think it's very interesting that Pemex should focus more on upstream and gas. And I would like if you could explain a little bit more, why do you think they should focus more on that? Because I think that's a very important part of what Pemex should do in the future.
Thank you, Oscar, for your questions. Concerning the first one, we're not ready, of course. I mean, we are still importing gas through LNG terminals, even from Qatar and from Peru. So this means that we cannot absorb all the American surplus and gas at the border because we don't have the infrastructure. And this is amazing because, as you know, NAFTA opened a private investment in gas transportations. I mean, we're talking about more than 21 years ago. There was no investment. I think that the problem is on the regulatory level. There was no certainty on how to deal with prices. There are a lot of subsidies, which is another aspect of Mexico's energy scenario that we have to transform. But now with the reform, it could be possible. So we're not ready. That's the answer. But we have the conditions in order to create a new environment of more transparency, of more regulatory certainty, in order that investors could participate in the midstream sector of transportation. Concerning your second question, I do believe that Pemex, we all anticipated that Pemex was about to change with the reform. The Mexican government talked about a new government competitive enterprise, but it never defined what it means. I mean, if you go to the law, there's no definition about what is a new government competitive enterprise. Mm-hmm. And during the discussions, they put a model. It could be Petrobras or Total in Norway. The two of them are public and they have private participation. Petrobras is not a model anymore. I think so, because it's a model of corruption, and we want to avoid that model also in Mexico, okay? So Total, well, that's a different environment. That's in Norway, which they have a strong welfare state, a strong rule of law. It's not the Mexican case. So we have no model. But that's good. Mexico must construct its own model. Mexico constructed its own model of public monopoly, which was successful at the time, I have to accept it, which was successful strategically as well, which was successful also for U.S. interests during the Second World War. We have to accept that. We have to know our own common history. But it doesn't work anymore. So Mexico must find its own model. Forget about Petrobras and Total. And I do think that Mexico, Pemex must, or other public enterprise, must have a strong upstream sector, both in oil and gas. First of all, because in most of the oil rent, even now, come from crude oil. And remember that Mexico's energy reform still defines in Article 28 of the Constitution that upstream activities are strategic, which means that are under the stewardship of the Mexican government. So I think we must fight to keep a public enterprise, debit as you name it, on upstream oil and gas as well, even though it's not a business now because of low prices we have to import. It's better to import than to produce currently. But we all know that the world gas is going global. Gas is going to be a global commodity in the next 20 years. And Mexico is better to electricity generation through gas, so we must keep that chain. The other chains, we can discuss that. We can open to private participation. We can make associations which are allowed by the Constitution, or we have to privatize some of them, for example, on petrochemicals. That's my point.
Right. Thank you. Does anyone want to ask any question to any of the speakers?
Yes, one.
Okay, here in the back, and then Miriam.
Jason Fargo with Energy Intelligence. A question for Isidro. You're talking about privatizing petrochemicals or sort of the non-core business areas. At the beginning of the reform, I know some people in Mexico were talking about possibly an IPO or a part privatization of Pemex itself at some point down the road after the political situation became less sensitive. Given that the Pemex's adaptation to the reform so far has been, to use your word, a failure, do you think that the government might now accept that? Videgaray has been talking about injecting capital into Pemex in some fashion. That would be one way, no?
Okay. Should I? Okay, thank you for the question. But you know that money is scarce, always. And as I told you, Pemex has been investing about $20 billion yearly, mainly in upstream, with no success. And most of it was on Chicontepec, which was, the CNH, our watchdog agency, stopped it because it says you must change the approach. Okay, that was a failure. We have to accept it. There are a lot of failures in the energy industry. So the point is, we don't have, Pemex doesn't have too much resources because still it is dependent on the Mexico's treasury. It's not a company as even as a government-owned company is not competitive because the Ministry of the Treasury decides its budget and has a strong position in order to decide its investments. So that's a major problem. And the government is also pulling a lot of resources from Pemex as well. So we have to change that. And then those scarce resources that the company will have, they have to decide with a board, because now we have some independent persons in the board, decide where to allocate those resources in the more efficient and optimal way. Think about investors and taking risk, but with social responsibility, because otherwise there's a huge social cost of those investments because they are our taxes for nothing. So that's my point. So if you concentrate, I think that you have to concentrate on upstream. I already said that. Gas, but you cannot bear all the risk. Pemex doesn't have to bear all the risk. That's the rationale of the reform. You know that Pemex didn't participate in the auctions. They were not allowed to participate in the auction, which I think is good. Why are you going to risk money if you still are having losses in your current investments. So they have to concentrate on which areas they want to keep and become efficient in the following 5 to 10 years. And then, as any other company, see your chains, which value chains are not strategic or necessary, or they are very costly. And I think that's petrochemical fertilizers. Fertilizers are very important for Mexico, but should Pemex past produce urea, for example, still? Or it can be better done by a private company. I mean, we have privatized petrochemicals also since NAFTA. And there's no huge private investment in the petrochemicals. Why? Because Pemex still monopolized natural gas and the feedstock in order to produce petrochemicals. So there was uncertainty in the supply. Now, with the reform, it won't happen anymore. So we have the new environment. So let's the environment to take off.
Francisco, you want
I just wanted to make a very brief comment on that. I don't think the political agreement is there for an IPO of Pemex, of the holding. I think eventually something that they might analyze is to do an IPO of a subsidiary. I'm not talking about downstream, and I agree with Isidro, they can do a lot of things in that. But I'm talking about the issue in which the resource nationalism, the core issue, which is upstream. And I think, you know, well, for example, what the Chinese have done, which is they didn't do an IPO on the holding company. They did it on a specific set of assets on a subsidiary that it's upstream subsidiary. That could be a potential option eventually for Pemex. By the way, I don't think that Saudi Aramco is going to do an IPO on the holding too, and I don't think that Pemex will do it anytime soon.
Thank you. Miri.
Good morning. Congratulations to all of you for your great presentations. They overlap a lot with my topic of research, so I think we're going to have a rich interchange when I get to deliver my presentation. When I have a question for Gabriel and one for Francisco. Gabriel, as you know, the decisions, the rulings of the regulators cannot be appealed directly before them, so they have to go to the judiciary directly to avoid lengthy processes of jurisdiction, of litigation. And that is, on one hand, convenient because you shorten litigation, but on the other hand, it creates a great deal of pressure on the Mexican judiciary to decide on topics that they might not be familiar with. I mean, they're going to be very, very technical topics, especially regarding, you know, prices and tariffs, permitting, environmental rules, industrial security rules, which the judges might not be able to address because basically they don't have the familiarity. So while arbitration is an available mechanism for the companies, as you well know, many of the companies which have won contracts are small Mexican companies which will not be able to finance a process of arbitration. So in terms of preserving the legal certainty and legal security, I think we have a huge void in terms of what the judiciary can offer for the companies and for the state. So that would be, I would like your comments regarding that one. And Francisco, I followed very closely the results of the 3 auctions for exploration and production, and one of the issues that has called a great deal to my attention are the very, very high offers from the companies. And while the government and other people assess that this is actually a triumph in favor of the government, it rather worries me because the prices of oil are very low and these are very new companies, especially in auction 3 when Hacienda was requesting a 10% royalty. These companies offered offered a 75% royalty when the world average is around 17 or 20. So my preoccupation with these issues is that the companies are not going to be able to comply with the contracts, and I think that there is a blindness in the regulatory bodies in their capacity to assess which is a reasonable, payable, functional royalty. Because we want to award contracts, but we want the companies to perform. So those would be my two questions. Thank you very much.
Gabriel?
Yes, thank you, Miriam, for your question. I have the same concern, of course, but I would like to be somehow optimistic in that regard. There are some previous experiences in the regulatory framework that has proved that the judiciary can adopt itself to this new regulatory framework, with some good experiences and some bad experiences, but they're working on that. Two examples come to my mind. One is antitrust law, and here we have the former chair of the commission, the Antitrust Commission, Federal Commission in Mexico. So the Mexican judiciary had to adopt itself to this new language of antitrust law in rendering decisions that have been very, very relevant for the whole legal framework. Again, probably some of them are better than the others, but they have to adapt themselves to this new framework. The other one was telecommunications, a very sensitive area, also politically, and well, you know that the Supreme Court has played a very significant role in some relevant decisions on the telecommunications. But training is going to be very important in this area, not only training for the judiciary, but also for all the regulatory bodies in Mexico. When I analyze what is one of the major challenges in the energy reform is precisely the necessity of training in many areas. I have heard all kinds of figures saying that we need training of thousands of people in the judiciary, in the executive branch as well, and of course in private companies in the framework of this new regulatory framework. So there's still a need for more training. And with respect to arbitration, again, although arbitration is the alternative dispute mechanism of choice in this type of contract, there is still a very long way to develop arbitration at the domestic level in Mexico. So that is another challenge. Arbitration is not yet in the Mexican domestic legal culture as any other mechanism of alternative dispute resolution. And for those companies which are not be able to have an arbitration, because it can be very expensive, we have to develop as well what we call small arbitrations or low quantity arbitrations that we do not have in Mexico. And again, training and a new culture in that respect is a challenge. So I share your concerns in that respect, and I think again, training and experience is going to be the answer. As I said, I'm somehow optimistic in the sense that at least the federal judiciary has proved that it's well prepared to face these new challenges. I think that many judges, because I have spoken with many of them, they understand the challenges that they are facing, and hopefully we are going to see something similar to what happened before with these two examples I gave in antitrust and telecommunications. That would be.
Yes, I totally agree with your concern on the issue of the high profit shares offered by the companies, and particularly in the 1.3. I think partly, I mean, everyone says, well, you know, they want to have a foot, they want to have a beachhead, and they have to be there, and it's sort of the price to get there. I do think that it's an issue that could be a big concern in the future, particularly because, as you mentioned, it will require very high oil prices for some of these projects to make any profit with bids that they offered. And so if they don't earn money, this might lead to failure and to. By the way, one thing that we haven't seen that much in oil, but for example, in infrastructure bidding processes, is that people offer too much and then they go and negotiate with the government afterwards. And I suspect that in the 1.3 projects, we might see some of that eventually happening, particularly because they are most of them Mexican companies, and they will go and beg the government for relief at some point. I think partly it's sort of what they call the winner's curse, which is the notion that the ones who offer the most are the ones who know the least, and that, and they really do not understand that this is not going to be profitable, and some, by the way, have offered way above the other competitors. So it shows that their offers were not particularly well designed. So I think that it is a source of concern, and it's sort of a bittersweet, as you point out, moment in which you can say, oh, we got it. We got a very high bid. On the other hand, is this going to be a reasonable contract to develop the sector? Sometimes might be a problem.
Thank you. We're almost on the time, so we have a last question over here. No, there's. Okay, there was. Okay.
Alan Anderson from Johns Hopkins. I think that the area of energy is particularly difficult because it is almost impossible to write an enforceable long-term contract. Who would have thought oil would be at $30 a barrel just a few months ago? And it could go well over 100 if people really get serious about the war in the Mideast. It's wrong to think that in the United States, energy contracts are written, signed, and enforced over their term. They're often renegotiated, and in particular, the Federal Energy Regulatory Commission in the 1980s forced the restructuring of almost all the natural gas purchase contracts to reflect the new market conditions. So it seems to me that we shouldn't expect these relationships, even under the rule of law, to be fixed and unchangeable. And secondly, I don't think we ought to demonize the countries for wanting to renegotiate the contracts from time to time. Private firms in the United States do that by mutual agreement. And I think any framework that emerges as Mexico develops an external investment environment has got to reflect the fact that there will be an ongoing relationship with periodic modifications of that relationship. Thanks for the very inspiring talks today.
Thank you. And we continue with the other question before the answer, so we can finish there on time.
Yeah, right there.
Over there.
Thank you. My name is Alfonso Lopez de la Osa. I am affiliate scholar at the Center for U.S. and Mexican Law at the University of Houston. My question is for Gabriel Cavazos. It's a question and a comment related to arbitration. The thing is, what is the reason that companies chooses arbitration? It's what I think may be one of the main questions. Why? Because they have faith in the judicial system, but also in the alternative dispute resolution, but then they choose arbitration. or it is because they see, like the judicial system in Mexico, not that much as a possibility due to the fact that maybe for the lack of training or maybe for the lack of trust in the judicial system. It is interesting to see how Mexico's energy reform can be linked to the rule of law. I think the reform has to be really from the root in Mexico, creating a system, a rule of law that also citizens but companies can trust. So they see that the judges are going to be either trained or counseled by experts in the process. That is why my question is, choosing alternative dispute resolution must not be by default for the fact of not trusting the judicial system. It has really to be an option, as you mentioned. For companies that may be not wealthy enough to face arbitration, and it's something that in Europe we are doing actually right now, we are developing other alternative dispute resolutions such as conciliation or mediation that are less expensive and that can be in the contract in case of such a dispute. But what I would like to say with this comment and also a question, why is the reason they choose arbitration? It has to be an option, and we have to reform from the basics, the legal system, in order to create trust in citizens when they go to judges. Thank you.
Thank you. Thank you. So Gabriel, and anyone wants to answer the other, and Francisco will answer the other question.
Okay. Well, I would like to make two comments. One, referring to the first question, it is true that energy contracts are difficult to enforce. It is true that restructuring and renegotiating contracts occur. And it is true as well that it is almost impossible in most jurisdictions just to freeze the regulatory framework because circumstances change from time to time. That is exactly what happened in Argentina's energy reform in the time of Menem and De la Rua. And precisely one of the key issues is in investment arbitration has been whether or not the change in the regulatory framework, given the different circumstances that a government is facing at that moment, violates the rights, the vested rights that the investor has under a contract or under the, in this case, a bilateral investment treaty. So the problem is when this changes in the regulatory framework, it is done with arbitrariness, with lack of transparency, with a violation, a clear violation of the legitimate expectations of the investor. And this is not a very easy task for the arbitral tribunals. And I would like to link this answer to your question here. So why is arbitration an alternative? I wouldn't say that there's a lack of faith or trust in the domestic jurisdictions. Of course, that happens in the case of unknown jurisdictions. But arbitration is still the method of choice, even for even in those jurisdictions in which the perception of independence of the judiciary is higher than in countries like Mexico or some other countries of Latin America, or even countries in Africa or in Asia. I think the key elements are, one is the expertise or the perceived expertise of the arbitrators. Another key element is time. Although in arbitration, well, I remember a phrase of one arbitrator, the sun doesn't always shine on arbitration. Sometimes an arbitration can be very, very long. And a bad arbitration may lead to a jurisdictional dispute. So that's even worse, because you have the worst of the two worlds. You have a bad arbitration, and then you have a jurisdictional dispute. So that's going to be very, very long, and that's precisely the case that I commented in my essay. So that's the worst of the scenarios, and that happens. But I think the choice is because of that expertise. The timing is perceived to be less, but of course, as you said, nobody recommends an arbitration when there is a small claim, because it's going to be very, very expensive. And again, we have to develop more systems, like you said, conciliation and other alternative dispute settlement mechanisms that are less expensive. So I would mostly refer to those parts: expertise, time, as the main reasons why arbitration is chosen by the investors in contracts. On the other hand, I will mention again that investment arbitration is not only available for contractual disputes. So investment arbitration is there even when, of course, there is a contract, but there is a violation of the investor rights under international law. And that is something that domestic tribunals wouldn't have jurisdiction to resolve under international law. That's an exclusive jurisdiction of an arbitral tribunal under the terms of a bilateral investment treaty or free trade agreement with a chapter of investment. So in that sense, a foreign investor would not claim damages for a violation of international law before a domestic tribunal, because a domestic tribunal wouldn't have jurisdiction to do that. So that's another alternative. Even beyond a contractual violation under domestic law, there can be a violation of international law, fair and equitable treatment standard, expropriation without an adequate payment to the investor, lack of national treatment, lack of the most favored nation principle, and so on and so forth. Those are principles, or those are standards of exclusively of international law, and that wouldn't be in the jurisdiction of a domestic tribunal. So that is why an investor, they have to waive all the pending damages claim that they have under domestic law to resort to an international investment arbitration, because the claim is different. The claim is under international law. So those are the issues that I would like to comment on, both questions that I think are very appropriate and very good. Thank you.
Finally,
very short
comment.
I totally agree that you cannot cover all the contingencies on the life of a 40-year contract. There are many. However, one is that the price of oil will vary, right? So we know that that has happened in the past. And one of the things is that many of these contracts and fiscal regimes did not capture well that the notion that if the price went up, the government will have a bigger share, and that of course generates incentive for renegotiation. The problem, of course, is that the government can also, renegotiate to the point in which it takes advantage of the opportunistic nature of the relationship, in which after the investment is sunk, you can dramatically change the terms, and that has happened many times. And so I agree that in the end, what you need is a system in which this changes. First of all, better contracts, and second of all, a system that allows for this renegotiation to be settled in a way that is reasonable for the future potential of investment.
Okay, well, we've run out of time. Thank you very much. Please help me thank our panel. Thank you. And let us